Hello, everyone, and welcome to the Labour Justice Barometer podcast. I'm Aisha Adam.
And I'm Debbie Collier.
And we're your hosts today on the Labour Justice Barometer.
Usually, Aisha introduces our podcast topic, but today we are a bit off script, as we were preparing to discuss a recent Labour Appeal Court decision on unfair dismissal in Machi versus CHEP SA Pty Limited, the CHEP case, but I kept harping on about the Constitutional Court decision on constructive dismissal in Maleka versus Boys, NO and others, which involved a resignation at the time that the security company ADT was acquired by Fidelity Services Group. So we ended up discussing both. Both cases involve senior employees. In the CHEP case, the employee was an HR manager who pretended to be ill, and instead of heading home to recuperate, she set off to chair a disciplinary inquiry for another company. She was dismissed on the basis of 3 charges that were stated on the notice of a disciplinary hearing. While at the CCMA, the Commissioner found her not guilty of these 3 charges, the Commissioner still found that the dismissal was substantively fair on the basis of an unexpressed 4th allegation, which the employee took on review. The ADT case in the Constitutional Court involved an IT director who resigned when ADT Security was acquired by Fidelity Services Group because of a new reporting structure that was imposed on him. He would still be the IT director, but he would be reporting to the finance director, who was familiar with the FSG systems and the SAP IT system that FSG would be implementing. At the time of his resignation, which was in 2017, the IT director had not expressly indicated that race was a factor in his resignation. This unexpressed allegation, it wasn't expressly called that, but it was included. Race was included in the Constitutional Court's dissenting judgment, which found that the circumstances were so egregious and intolerable that he had been constructively dismissed, which was contrary to the findings of the CCMA, the Labour Court, and the Labour Appeal Court, as well as the majority decision of the Constitutional Court. Thanks, Aisha, for accommodating the last-minute change. And let's start with the CHEP case and the question whether an employee can be fairly dismissed for misconduct that was never actually formally listed in the charge sheet. Aisha, talk us through the facts and this intriguing feature of the unexpressed 4th allegation brought into the mix by the CCMA Commissioner.
So, Debbie, what makes this case so compelling is that it sits at the intersection of procedural technicality and substantive justice. Nontobeko Machi, the employee, was a senior HR business partner at CHEP, so ironically someone whose job it was to manage exactly these kind of processes. And in July 2017, she was in Cape Town for a company awards event. On the morning of the event, she told her manager she wasn't feeling well and emotionally shaken by her colleague's suspension, and her manager gave her permission to fly back to Durban early. But here's where it gets interesting. When she landed in Durban during normal working hours, she didn't go home and she didn't go back to the office. She went to a company called Zala Corporates, chaired a disciplinary hearing there, and then issued a written finding in which she described herself as the HR director of Zala, a title she simply did not hold. CHEP found out, launched an investigation, and charged her with 3 things: gross negligence around a separate recruitment matter, dishonesty about faking illness to skip the event, and gross misconduct for failing to disclose a conflict of interest. She was found guilty on all 3 and was dismissed. At the CCMA, however, the Commissioner acquitted her of all 3 formal charges by finding no hard proof she'd lied about being ill, and no proof she was actually a director of Zala. And yet the Commissioner still upheld the dismissal as substantively fair, based on conduct that was never formally charged. But that's where this legal question explodes open. The Commissioner identified what she called an unexpressed 4th allegation, which is essentially the core factual issue running through the case, that the employee had used company time under false pretenses to perform work for another entity. And on that basis, the Commissioner upheld the dismissal as substantively fair while awarding 2 months compensation for procedural unfairness.
Thanks, Aisha. And I assume then that the employee took the dismissal on review and ultimately appealed to the Labour Appeal Court against the dismissal?
Yes, and the issue that ultimately reached the Labour Appeal Court was whether relying on misconduct not explicitly listed in the charge sheet was permissible. Debbie, what the Commissioner meant by an unexpressed allegation is not completely new or unrelated charge, but is in essence the true substance of the misconduct that was always embedded in the facts of the case, even if it wasn't neatly expressly articulated in the charge sheet. After acquitting Machi of the 3 formal charges, the Commissioner essentially stepped back and asked, but what actually happened here, and what emerged from all the evidence was this. During normal working hours, having been released from a work obligation on the grounds of illness, she chaired a disciplinary hearing for a third party and held herself out as a director of that business. The Commissioner called this an unexpressed 4th allegation, meaning it wasn't written on the charge sheet, but it was the factual thread running through the entire case. It was the bridge between 2 of the charges she'd been acquitted of. Charge 2 was about dishonesty. Was she really ill? Charge 3 was about conflict of interest. We asked, was she acting as a director elsewhere? The Commissioner found she couldn't be convicted on the strict technical wording of either charge, but the underlying conduct, which was using company time under the guise of illness, to work for another entity was undeniable and had been front and center throughout the whole disciplinary process. So in my opinion, the commissioner was essentially saying, I'm not going to convict you of the label, but I can't ignore what you actually did. And so the Labour Appeal Court also drew from this substance over form principle in the EOH Abantu case and emphasized the point that the employee had adequate notice and suffered no prejudice.
Thanks, Asha. So before I ask you where the case sits on the Labour Justice Barometer, the ADT case is important in terms of the concept of intolerability, which we've discussed previously in episodes 15 and episodes 19, which deal with intolerability in the context of the reinstatement remedy. But intolerability is also important in the context of a constructive dismissal, which the ADT case involves. And in the Constitutional Court, the majority decision confirms indeed the three requirements for a constructive dismissal. The first is that the employee must have terminated the contract of employment. This is typically by resignation. And the second is that the termination of the contract must have been that continued employment has become intolerable for the employee. And the third is that it must have been the employee's employer who made continued employment intolerable. And it is these elements that the court engages with. So critical questions that arise in determining whether or not intolerability meets the threshold, and the Constitutional Court in the majority decision reaffirms that the threshold is a high threshold. But two critical questions that arise are, what is the level of personal discomfort or affront that an employee is required to endure in the workplace before resigning? And also the extent to which an employee must exhaust internal or other remedies before resigning. The majority decision articulates the prevailing position in law that intolerability means a situation which is beyond that which can be tolerated or endured, and it must be insufferable, something which is too great to bear, to put the matter beyond the limits of tolerance. So the threshold test is high. So let me tell you about the facts in Maleka. Maleka was a senior employee, an IT director who worked at ADT, which at the time was a subsidiary of an Irish company, Tyco. So his direct line of report was initially to Mr. Birmingham in Ireland, and he only had a dotted reporting line to the ADT managing director, Mr. Clarkson. But when ADT was about to transfer to Fidelity Services Group, he was told that he would be reporting to a new financial director. In other words, a director on the same level of authority as he himself was. And this is unfortunate. He was only advised of this at an EXCO strategic planning meeting, in other words, a public forum, that he would be reporting to a Mr. Quinn, and that Mr. Quinn would have some authority over the IT portfolio because of his experience with FSG and its SAP IT system. He was unhappy and he spoke to the MD, Mr. Clarkson, but after this discussion, he decided to hand in his resignation. And in his letter of resignation, he states that he'll not accept the change in reporting line and that I have to make decisions that advance my career. The change will demote me to a manager or senior manager level. The career implications are clearly negative, which I cannot support. The painful truth, of course, is that he has been unemployed since his alleged constructive dismissal in 2017. And as the Constitutional Court notes, as a result, he has been rendered indigent. So let me tell you about the labour dispute chain. After he resigned from ADT, he referred a constructive dismissal dispute to the CCMA. And the onus, of course, being on an employee to prove the dismissal and hence to prove that the employee made continued employment intolerable. The Commissioner, however, found that his contention that the change in his reporting line made his continued employment intolerable was devoid of any substance. He should have pursued internal remedies. Mr. Maleka then took the Commissioner's award on review. And the Labour Court confirmed that on the question of constructive dismissal, the applicable test on review was whether the Commissioner's decision was objectively speaking correct. And that although the rule that an employee ought first to exhaust a grievance procedure prior to resignation is a flexible rule, in this case, Mr. Maleka's failure to provide compelling reasons for not having followed ADT's grievance procedures was detrimental to his claim for constructive dismissal. In other words, his conduct was impulsive and not a measure of last resort. Mr. Maleka then appealed to the Labour Appeal Court, and in its judgment, the Labour Appeal Court took further issue with Mr. Maleka's failure to refer an unfair labour practice dispute to the CCMA on grounds of a demotion, or an unfair discrimination dispute, which would have provided opportunities to resolve his grievance and to avoid the resignation. The Labour Appeal Court found that his situation had not become unbearable or intolerable, and that he had not discharged the onus of proving on a balance of probabilities that there was a constructive dismissal. Mr. Maleka then approached the Constitutional Court. The court was divided, and the majority decision was agreed to by 5 of the justices, and the dissenting decision by 4. The majority decision follows the line of reasoning in the CCMA and the Labour and Labour Appeal Courts that intolerability requires something more than conduct which simply results in difficult, unpleasant, or stressful situations for the employee, and agreed with the Commissioner that the employee's failure to lodge a grievance worked against him. But the majority was not unsympathetic, and they recognised that the public announcement of a change in his reporting line must have caused him considerable anxiety and embarrassment. There had been no prior consultations, and despite being assured that he would retain his title, his status, his salary and authority, the reporting change could reasonably have been perceived as a demotion, which was hurtful and insulting. But nonetheless, that he should have pursued other means prior to resigning. On the other hand, the dissenting judgment felt that the resignation was a measure of last resort, and this is because of the circumstances. And these relate to the race of Mr. Maleka and the race of Mr. Quinn, and that he had suffered considerable humiliation in the circumstances in which he was advised of the change of reporting. And so the dissenting judgment is of the view that the hurtful insult and assault on his dignity had an immediate effect, and that these gave rise to the intolerability immediately, and hence his resignation was justified. The dissenting judgment would have found that he had been constructively dismissed and that the dismissal was unfair. And although the dissenting judgment would not have ordered reinstatement, they would have awarded a compensation of 12 months' salary.
You're listening to the Labour Justice Barometer, and we'll be right back. Debbie, you talk us through just this dissenting judgment. I want to know, what are your views about the dissenting judgment?
So, Asha, I think we must accept that race and perceptions of unfair discrimination are prevalent in our workplace and need to be taken seriously, need to be engaged on and dealt with and resolved. What worries me is the message that this dissenting judgment is sending to employees who may feel aggrieved in the workplace. It almost seems to suggest that you should walk out. You should not try to resolve the matter. Which doesn't seem to me to be constructive, particularly given our racially charged and the diverse composition of our workplaces and the typical misunderstanding and frustrations that arise. We should be able to, and we should have the mechanisms to engage around those. I also worry about the extent to which the minority judgment states that we shouldn't engage on these issues because this could potentially give an opportunity, for better communications and to build better organizations. But instead, the message is you are justified in walking out. You are justified, in essence, to walk into the ranks of unemployed, which we hear. An award of 12 months compensation is hardly compensation for almost a decade of litigation. So I just think we should be asking questions about what we actually want to be happening in the workplace when an employee feels aggrieved and where race might be an issue. And by race, I mean any characteristics that make us different from our fellow employees. I worry about the direction that the dissenting judgment gives us. But there's a second issue for me too, is around second-guessing the employee's reasons here for the new reporting line and the genuine operational requirements of the employer, and to what extent the court should be stepping in to the role. And I don't feel that the dissenting judgment engages with this adequately. Aisha, I'm just not convinced about the soundness of the reasoning of the dissenting judgment. But I'm noticing the time, and perhaps it's the right time for us to get to our Labour Justice Barometer question. So cast your mind back to the JEP case and let me know what you think.
For me, if we're looking at the JEP case once more, I think this sits in the orange, maybe leaning towards more of the green, I think. I say this because on the one hand, I do think the judgment is positive because it does avoid a purely technical outcome where serious misconduct is overlooked simply because of how the charge was actually framed. But it reinforces a more realistic and substance-driven approach to fairness. At the same time, however, it does raise concerns about how far we can actually stretch this flexibility before we actually start to undermine procedural clarity and certainty. So we must remember the charge sheet still plays an important role in structuring fairness. What about for you, Debbie, and more so in the ADT case as well?
Yeah, thanks, Asha. I mean, I'm tending to green on the JEP case in terms of the outcome. I do worry about us over-formalizing the disciplinary processes, and in terms of the obligations imposed on the employer. The obligation of fairness is key, but that can take many forms. I have to say on the ADT case, I guess the confirmation of the principles for constructive dismissal is good. I do think that some reflection on the threshold is good, and the extent to which an individual's subjective characteristics might play a role. To be honest, I'm still seeing a little bit of red, and particularly on the delay, the time delay. These are both 2017 cases. That's a red flag in terms of labor justice. I don't seem to be able to get out of the red today. Thanks, Asha.
Thanks, Debbie. And to all our listeners, all the details of the case are in our description. And Debbie, I'll see you in the next one.
Thanks, Asha. See you soon. This podcast is not intended to constitute legal advice.